problems of European small claims procedure. And we are going to give some example, as Carmen just said, about the implementation of this process in Spain, because I think that probably the problems of this process are quite common in all the countries in European Union. First of all, I'm going to remind you the features and the scope of this procedure. As all of you know, regulation of small claim procedure was supposed to be simplified and accelerated cross-border litigation on small consumer and commercial claims as recital 4 of regulation of the European small claims procedure established. In this, let's say, definition or exposition of what the scope of the process is, we may find the main features of this process. First of all, it is a declaratory process, which allows the claim of pecuniary and non-pecuniary claims arising from cross-border civil and commercial matters up to 2,000 euros. This figure changed in year 2015, as you will see a bit later. And this is a process in which the judicial protection is facilitated through the use of certificates or standard forms in order to overcome the difficulties of the different languages in the countries of the European Union. Small claim procedure has been very often object of study among the doctrine and also practitioners. But in spite of that, I'm afraid it is not very well known among citizens, and statistics about its use in Spain show very low figures. I'm afraid I cannot offer you any figure because it does not enter in official statistics. But if we try to find judicial decisions about the judgments given in the small claims procedure in Spain, we can find just about 40, maybe 50 judgments during the whole application of this regulation. So that can give us some idea about how low is the use of this European process. In most member states, as Vesna Rijovic said before, there are some processes for the recovery of debt that follow a similar technique to the small claims procedure. And these kind of processes, domestic process, I mean, are usually used very often. Just to give you some figures in my country. In year 2018, sorry, because I didn't put the year on the slide, there were, on the whole, in my whole country, there were 2,250,000 civil claims in whole. And 500,000 of the national small claim procedure. So you can have an idea how often is used the domestic procedure in my country. And the reason for this success is probably that this process is very effective when the debtor has no economic, possibilities. In case of insolvency of the debtor. Any opposition in the event of insolvency would only serve to lengthen the process and to make it more costly. And this will even increase the debtor's the condition. So if the creditor is aware of this situation, if the creditor knows that the debtor has no possibilities to afford the payment of the debt. This is, I would say, the best way to get very easily an enforceable title. And it can be very useful because this way the creditor has his enforceable title in the moment the debtor recovers or his economic capacity. As it happened in domestic law, these features and this effectiveness of the small claims procedure in case of insolvency of the debtor could lead us to believe that this process, the European small claims procedure, was going to have a great success. But this is not the case at all. Far from that, a small claim procedure is little used and little known among citizens of European Union. Article 28 of Regulation 861 of the year 2008 established, as you all know, a review by the 1st January of the year 2014. At that moment, it was supposed to be, and actually it was, a review on how the small claims procedure was working. This report was carried out by an external body who was Deloitte Associates, and also there was a questionnaire that was sent to all the member states at the European Union, and also more or less about 80 associations of consumers, citizens, judges took place in this review. This review did not prove bad results at all. In general, there was a very positive assessment about how small claims proceeding was working. But of course, there were somehow a certain underutilization of the process. And this underutilization is due to some dysfunctions about the application of the rules of the process. There were some shortcomings in the forms, probably an important limit in the scope of the small claim procedure because of the definition of what a cross-border claiming is supposed to be, and also because of the amount of money that could be claimed through the way of this procedure. So there were shortcomings and gaps in the regulation, and in addition, usually consider that any type of non-domestic process is usually excessively complex, but does not always correspond to reality. But I'm afraid this is a little bit the idea of not only citizens, but also lawyers, practitioners. As a consequence, and despite this criticism, no one claims for its abolition. But of course, European authorities consider that the regulation of the small claim procedure could be absolutely improved. So there were some amendments that were introduced in the regulation of the ESCP through the regulation 2015-24-21. Well, let's see the main amendments. Of course, we are not going to go all through all of this, but just to give you some, some idea about where are the main amendments in this regulation. First of all, and in order to achieve a wider use of this process, regulation of 2015 established that the procedure in all member states should be compatible with the regulation of small claims procedure. In some countries, there were amendments in the domestic regulation, in the domestic civil procedural laws, in order to achieve this compatible procedure. Also, a second important amendment in year 2015, the idea of what a cross-border case is. A case is considered a cross-border case if one of the parties is domiciled in one member state and the other different than the member state where the court seat is. And from the amendment, the moment for the determination of a case as cross-border is the one in which the claim is received. I would like to let you know that there was, before the amendment of year 2015, that there was at that moment a proposal from the Commission to allow consider cross-border cases, those in which both parties were domiciled in the same member state. But there was a strong foreign component. For example, two parties domiciled in France, let's say, that enter into a contract, both of them in Italy, or that they live in Germany and they suffer damages from the other person in Poland, for example. All these cases would have entered in this broad idea of cross-border suggested by the Commission. Well, it is obvious that this proposal was not successful, and finally the regulation was not so wide. But at least it shows, in my opinion, the high interest of the Commission in broadening the scope of small claims procedure. Well, we have also the limit in the amount of the claim. In year 2007, the limit on the claim was on 2,000 euros. And some years later, with this amendment, it rises to 2,000 euros. Right, 5,000 euros, that's right. And another important amendment, the use of communication technologies. The use of this means covers a large number of issues, but maybe in the information, in assistance, in the service of the documents, and also in the oral hearings. We will see it a little bit later. Well, in this presentation, we are not going to, to go through all the steps, all the procedure. What we are going to do is see the more important issues, mainly from a procedural point of view, which issues are still a weak point in the regulation, and also how are working the amendments introduced in year 2015. And in this analysis, we are going to find some examples in the implementation of this process in Spain. So let's continue. Well, as I told you, the amount of the claim raised in year 2015 from 2,000 euros to 5,000 euros. And the aim, the regulation said that the aim of this change was to improve the access to justice of the citizens of European Union. Well, I would like to turn for a moment to an example from Spanish domestic law and how is working our domestic small claims procedure that, as I told you some minutes ago, it is working really well. Well, in here, we have a domestic procedure based on the monitio technique, that is, the order for payment technique, let's say. And in Spain, this process did not have expressly right now, does not have the feature of the small amount. But in the original drafting of the civil procedure law, there was a limit. In year 2000, we have a new civil procedure act, and this process was introduced. And at that moment, we didn't have the euro yet, but the limit for the process was more or less 30,000 euros. Only 9 years later, as you may see on the slide, the limit rises to 250,000 euros. And 2 years later, in year 2011, the limit is absolutely suppressed. And what is the reason for these changes and the final suppression of the limit of the process? Well, the reason is the extraordinary success about the use of this process. Spanish legislator wanted to allow every debt to be claimed through this process. Well, I am afraid that in what concerns to the small claims process, the reason of this change in the amount is probably the opposite. Not the success, but the fact that very few citizens in the European Union claim their debts through the small claims process. That's why that's the reason for the amendment of this regulation, this change in the limit of the small claims procedure. I would like to underline that citizens usually do not go to court to claim very low claims. I mean, obviously, the limit on the claim, or let's say the amount which a citizen considers that it is worthwhile to take legal action varies in many factors. For example, the financial capacity of the claimant, also the grounds of the claim, his familiarity with the judicial system, and other factors. While this is already the case in domestic law, in the European law, the deterrent factors are even greater, because we can add as well the fear to unknown consequences, the barrier of the foreign language in spite of the use of certificates, so and the fear to the consequences, and the fear to do not know how to follow, and the fact that we don't have the court closer, we cannot go in person to the court, etc. And we could say that around an amount of, let's say, between 100 and 500 euros, usually citizens do not go to court. I mean, they may try extrajudicial solutions, ADR, or negotiation, but it is difficult for that kind of amounts to go to a remedy that involves the payment of a certain amount of money. And well, from this point of view, I mean, the low use of a small claims procedure in the European Union, the idea of raising the limit to up to 5,000 euro, in my opinion, has to be very welcomed. And it obviously increases the possibility of using of this project. It has been pointed out through several seminars on these projects that both the European small claims and also the European order for payment have proven to be unsuitable for their resolutions. Does it mean something? We had a red light. You still here as well? Let's hope so. Well, I was saying that the European process is not very suitable for small consumer claims. And this has to be taken into account if we want to offer a really, a really efficient means to solve smaller amounts. Well, if we intend to arbitrate means that can also be useful for minor consumers, the solution necessarily must involve that the claim should not entail a lawyer's fees and that the consumer must be informed at every moment about how the costs are going to be calculated, if the process is going to cost him some money or not. And for example, it is also important for the parties to know whether they are going to be able to withdraw their claim at any moment or not, etc. In what concerns to costs and in general to expenses, regulation establishes that costs must be reduced and the details and means of setting these costs has to be transparent. However, member states do not always comply with this wish of the regulation. I say wish of the regulation, but it is included in the recitals of the regulation and not in these articles. Article 16 lays down the rules for the awarding of costs in the proceeding, but does not require any contention on the fees. In any case, the importance to achieve a process that it's not very costly, very expensive for the parties was highlighted in the regulation, in the amendment of the regulation in year 2015. In this year, the text that in regulation 2007 was part of the recitals was included in Article 15A of the regulation. And despite this intention of European legislator to maintain costs in reasonable limits, the truth is that it does not go so far as to establish a mandatory rule. So the costs of the proceedings depends on many circumstances, such the legal tradition and the per capita income in every member state. What Article 15A established is that the settings of costs must be transparent and that there must be different methods of payment, so the claimant has easier to pay the claims of the process. So it is not easy in any case to keep the costs in a reasonable limit, considering that the small claims process is not very familiar for the lawyers. And also there is an international element that make the lawyers' assistance more expensive than in other cases. And this is what happened in the case solved by the Commercial Court of Madrid in September 2016.
Okay, I'm going to comment this judgment. So the claim was through a small claims procedure, and the procedural costs were of an amount of 1,200 euros. So this amount exceeds very much the limit of 1/3 of the value of the debt that was the maximum amount to be claimed on procedural costs according to the rules of the Council of Lawyers of the place where it was of Madrid, in the place of the debt. However, the plaintiff considered that there has been bad faith from Iberia, and therefore the amount could exceed that limit that was suggested by the Lawyers' Council. The decree that ruled on the procedural costs reduced the amount of 1,200 to 600 euros. And then the appellant contested on the grounds that he had to pay a lawyer because he resided in Germany. It was far from the jurisdiction of the competent court. But this claim, the appellant's claim, was not upheld. What did the judgment said, or what was the grounds to deny the claim of this Mr. T that claimed so high procedural costs? Well, the ruling said that the aim of the small claims procedure was to keep costs to a minimum. Well, the aim, this procedure tried to keep costs to a minimum, and expressly states in Article 16 that no costs are necessarily generated or not proportionate to the value of the claim will be admitted. Therefore, if the party favored by the order for cost is assisted by a lawyer, the cost of such legal assistance will be included only if it is proportionate to the value of the claim and is considered necessary. It is true that the intervention of the lawyer in this case was necessary because this man lived in a different country, but his fees were disproportionate to the debt. What can we comment here? So very briefly, we can say that despite this understandable target of the small claims procedure regulation to keep costs low, it is very difficult to implement it in practice because the lawyers, they want their fees, and it is quite complicated to maintain that balance between the benefit and the fees that they want to recover. And moreover, Article 10 of the regulation does not require expressly procedural postulation, and thus the justification of legal costs that include a lawyer's fee is even more difficult. So that's why this ruling, or much better, this ruling shows how difficult it is to maintain, to keep the costs low as it was supposed to be the target of this regulation.
Well, let's move to another issue of this process, that is as Professor Rijeka has just pointed out, there are in the domain of the European Union a plurality of means for the recovery of debt. We have, I have not included in the slide the regulation of the European Account Preservation Order or other instruments in case of insolvency. I've only included here the commonest means for the recovery of debt. And so we have first of all, the European Enforcement Order. That, I mean, it is a mean that has been regulated in Regulation 805 in year 2004 of the European Parliament on the Council. It was issued, it was passed in April 2004 and created the EEO. This order implies the possibility to ask for the enforcement of a judicial decision that has been taken without an opposition of the debtor. And then we have the two main processes that are the scope of the work in this project, that are the European Order for Payment and the Small Claims Procedure. Well, both of them are declaratory proceedings. The latter has a limit in the amount. And so these are the two options in a cross-border recovery of debt. However, these two means, these two declaratory proceedings, coexist with the domestic processes. And sometimes they are a single process, but in other cases, we have a plurality of means. This is what happens in Spanish internal law. I mean, in Spain, we have two domestic proceedings for the recovery of debt. We have a special process that it's very, very similar to this small claims procedure, but from year 2011, we have no limit in the amount. And then we have an ordinary proceeding. Well, the advantage of this situation of a plurality of the European and domestic means is obvious. The litigant can choose the means that is more suitable for him or for her in accordance with this economic criteria or the duration of each process or the rules of jurisdiction or any other feature of the regulation. In my opinion, it cannot be said that all these means for the recovery of debt have confusing limits, not at all. I mean, the distinction among them is, I think, very, very clear. But the difficulty for the claimant may come rather from the fact that existing all these procedural means that are very similar, it can be a bit confusing at a certain moment to decide whether one or another is more convenient for the claimant. Just as an example, let's think about the difference of having the possibility to hold a procedure in the own country of the claimant or having to develop the process in a foreign language, or the possibility to to be on the process without the assistance of an attorney or not, etc. Furthermore, it is striking that in spite of this variety of means, the very, very small claims are not very well protected. And the fact that there are different means for the claiming of debts can easily lead to lease pendants or false lease pendants problems. Because in many times the persons involved in the debt, they can initiate similar processes in which there is an obvious connection of the object of the process. One of these cases was solved by the Court of Appeal of Barcelona in May 2014.
Okay, I'm going to comment this case. I hope it will not be very confusing because I'm going to talk about different dates, different amounts. So with the scheme you have in the screen, maybe you can follow it a bit easier. So the case involved Keitel, that is a company for marketing and rendering services of tourism, different services. And the other party was FM Hotel. And the issue at stake here is the lease pendants. Well, what were the facts? The hotel claimed in June 2012, claimed 1,160 euros from Keitel for non-payment of bills for the lodging of clients, Keitel clients, that have been in the hotel. So it's really a small claims procedure. Keitel opposed the claim on the grounds that the hotel owed Keitel a higher amount than the one claimed for the service rendered and filed a counterclaim. As the documents show, in April 2012, Keitel had initiated an European order for payment procedure claiming the hotel the debt it had with Keitel. The hotel objected without giving a reason. As we know, there is no need, the regulation does not require giving a reason, but submitted the invoices which later were used as a justification for the small claims procedure against Keitel. The court decision considered the link between the two proceedings to be obvious, which led the court to confirm the lease pendants and the consequent dismissal of the proceedings. Well, the plea of lease pendants seeks to prevent that controversy previously submitted to the court affects another lawsuit with the possibility of reaching contradictory judicial decisions. Thus, it acts as a preventive legal institution and a protection against res judicata. Both figures, lease pendants and res judicata, share the same basis or purpose. Lease pendants is regarded as an anticipation of the res judicata insofar as both deal with procedural univocity and the legitimate right of the party not to be subjected to double litigation. Lease pendants requires an identity in relation to three elements: the subject, the cause of action, what is called the causa petendi, and the claim of both procedures. However, in Spain, the Supreme Court admitted improper or connected, well, the so-called improper or connected lease pendants in which one of these three elements is missing. In this case, in the Keitel case, the identity of proceeding is not absolute. You remember that the procedures were different. One was a small claims procedure and the other was an European order of claimant procedure. Moreover, the identity of the object is not absolute either. There is certainly a subjective identity. The parties were the same, but the objective identity was not total, because in the subsequent, in the small claims procedure, apparently one more bill was added to the claim. Well, however, despite this lack of absolute or total identity, I mean, in the three elements, the appellate court confirmed that it was a situation of lease pendants because the facts that are mutually demanded derive from the contractual relationship that the two parties maintain. The documentary evidence is constituted in both proceedings by the same invoices or bills. It follows from all this that there is a clear possibility of interference between the two proceedings, and therefore the subsequent proceedings, which in this case was the European Small Claims Procedure, must not be admitted. The Brussels I regulation is, as you know, the Regulation 44/2000 on jurisdiction and enforcement in civil and commercial matters, has not been applied. The lease pendens in this case is resolved. The lease pending is resolved in that regulation, although there is nothing in the regulation of the small claims procedure, Regulation 861/2007. The connection of lease pending with the rules of jurisdiction, for which Brussels I regulation does apply, might lead us to think that the case law would also refer to Brussels I in its legal argumentation, but this judgment does not do so. It refers directly to arguments from Spanish case law to assess lease pendants.
European small claims regulation does not contain rules of jurisdiction. And in order to determine the rules of jurisdiction, we have to apply Brussels I recast. Application of Brussels I is not established very clearly in the regulation of a small claims process. We have recital 27, that says that the court must include a person qualified to serve as a judge in accordance with national law. And then we have Article 4 of Regulation 861/2007 that just regulates that the standard form A must be filed before a court or tribunal with jurisdiction. And actually, the clearest rule, that it's not properly a rule, is in standard form A, because in this standard form, there is a statement that says the court must have jurisdiction according to the rules of Regulation 44/2001 on jurisdiction and the recognition and enforcement of judgments in civil and commercial matters. Well, now, as all of you know, this reference shall be done to Regulation 1215 of year 2012. The amendment of Regulation 861 that took place in year 2015 didn't change anything about this lack of rules of jurisdiction, and neither included a more specific reference to Brussels I recast. So we have the same reference to the application of Brussels I in order to determine the court with jurisdiction. So the fact, so we have a regulation, Brussels I recast, that is applied to determine the court with jurisdiction. It is not, as you may see on the slide, this application is not established very clearly on the ESCP regulation, but it has not been contested. However, a Spanish legislator, in one of our rules of domestic law, established that the application of Brussels I in order to determine regulation in the European Order for Payment and in the small claims procedure. Of course, this domestic rule is not strictly binding because Spanish legislator cannot contradict at any moment the European regulation. But it is interesting, in my opinion, to verify, to check that Spanish legislator express very clearly what regulation of the small claim procedure does not state in such a clear, let's say, such a clear way. Well, so we have Brussels I recast for the determination of the competent court. The fact that Brussels I has been applied in practice for a number of years could lead us to believe that this issue has been overcome. But actually, the determination of the court with jurisdiction, it is always a tricky question. Article 25 of Regulation 861 of year 2008 established that member states shall communicate to the Commission which courts have jurisdiction to deliver a judgment in the small claims procedure. However, this determination of the court in the member state refers only to the court with objective competence. But in every member state, in order to determine the territorial jurisdiction, we have to apply a Brussels I regulation once again, and only if it is not possible to determine the territorial jurisdiction through Brussels I, we have to go to domestic law. I would like to underline that in some countries, this second determination of Article 25 that says that every member state has to indicate to the Commission which is the court or tribunal with competence, objective competence for the small claims procedure. In some countries, this is an only court. I mean, there is, it is only, a single court with jurisdiction. But in some other countries, as it happens in Spain, there are a plurality of courts with potential jurisdiction. So we have to determine the territorial jurisdiction in the domestic, from a domestic point of view. So we apply Brussels I, and only if it is not possible for territorial jurisdiction, we apply domestic law. This is what happened in the decision of the Appeal Court of Madrid.
Well, this is a complicated case that happened took place in Madrid. Here, the Court of First Instance declared its lack of jurisdiction to hear the European Small Claims Procedure or for payment procedure. It pointed out that the territorial jurisdiction, in accordance with the provision of the law for 2011, is determined by the domicile of the party against whom enforcement is requested or by the place of enforcement. Then it applies the Spanish procedural law, which determines the jurisdiction of the court where the debtor is domiciled. The plaintiff appealed, claiming that the applicable rule was Article 5.1 of Regulation 44/2001, which not only confers jurisdiction to hear this type of proceedings on the courts of the state where the defendant is domiciled, but also on the state where the obligation has been or should have been fulfilled, as it was the case here. The court agrees with the plaintiff. According to Regulation of the small claims procedure, Regulation 861/2007, Spanish law, and therefore the Spanish law on procedure, will apply only if the jurisdiction cannot be determined by applying the rules of Regulation 44/2001, which allows the plaintiff to choose between the state where the defendant is domiciled or where the obligation has been or is to be fulfilled, which in the case of a sale, that was the case I'm referring to, will be the state where the goods have been or are to be delivered. And as according to the documentation provided, it is clear that the deliveries were made in Madrid, the jurisdiction undoubtedly corresponds to the courts where the lawsuit was filed. The curious thing about this case is that it invokes the Spanish rule which states the application of Brussels I regulation and not directly Regulation 861/2007.
Well, just a short introduction to the next case, the case solved by the Court of Appeal of Alicante, because as you all know, Brussels I establishes that the general criterion for the determination of territorial jurisdiction is the defendant's domicile. But to this main criterion, legislator adds special rules relating to certain matters, such as consumers, insurance, or damages. And we have an interesting case solved by the Court of Appeal of Alicante in October year 2010.
Well, tomorrow there will be a presentation specifically on consumers, but anyway, I'm going to talk shortly about this resolution. Well, in this case, the Court of Appeal of Alicante applies the Brussels I regulation. It is relevant because it is a consumer contract. If the consumer is the defendant, then the plaintiff can choose between the courts of his domicile or of the defendant's domicile. In this case, the Court of First Instance considered that since it is a claim arising from professional services against a client domiciled in Germany, Spanish jurisdiction does not apply. This conclusion will be confirmed in accordance with Article 16, which states that an action brought by a consumer against the other party to a contract may be brought either in the courts of the member state in which that party is domiciled or in the courts of the place where the consumer is domiciled. Persons domiciled in a member state may be sued in another member state in contractual matters in the courts for the place where the obligation which forms the basis of the claim has been or is to be performed, because this is a general rule which must yield to the specific rule which, under the heading of jurisdiction in matters relating to consumer contracts, is contained in Articles 15 of the Regulation 15.1.2 of the Regulation 1408/71 and 16 of the Regulation, since the latter provides that an action brought against the consumer by the other party to the contract may be brought only in the courts of the member state in which the consumer is domiciled, as opposed to the case where the consumer is the plaintiff, in which the action may be brought in the courts of the member state in which that party is domiciled or in the court of the place in which the consumer is domiciled. Since the defender is domiciled in Germany, the courts having jurisdiction there have jurisdiction to hear the case.
Well, let's move to the following issue that is very interesting. Well, it's interesting in my opinion. That it's about the use of modern technologies. one of the issues that the amendment of the rules of the process in year 2015 was the use of modern technologies in order to overcome the consequences of geographical distance and the costs of the procedure, as Recital 6 established in the regulation of year 2015. The use of modern technologies has a very clear impact on two of the main disadvantages of the process, the duration and the cost, and reduces both. This is a measure that should be very welcome because it can mean a lot in terms of promoting the use of this process. There are two issues that are particularly sensitive to the use of modern technologies. One of them is the service of documents, and the second one is the celebration or the holding of a oral hearing. Both of them are explicitly referred to in the 2015 amendment of the regulation. Let's talk first about the use of modern technologies in the service of documents. I remind you that the service of documents to the parties is a very highly sensitive issue in civil proceedings because it is not just a matter of speed or of economy, but also a matter of protection of procedural rights, of the rights of the defendant. And it was, in what concerns to the use of modern technologies in the service of documents, in my opinion, it is very surprising that in year 2007, when the use of technology was already, common among most of the European citizens, Article 13 of the regulation still requires a postal service attested by an acknowledgement of receipt. However, Article 13 of the amendment of year 2015 allows the service of documents either by postal service or by modern technologies. The use of modern technologies is allowed in the service of documents under two circumstances, either when the domestic procedural rules allow the use of this means of communication for the service of documents, or when the party has already accepted in advance to be served by any of these means. In what concerns to the service of documents, it is important to underline that the use of this technological means of communication is, I think it's going to be very important, not only to simplify the procedure and to shorten it and to make it cheaper, but only it will help to notice effectively the defendant. The saving of time is quite obvious because we can skip the use of the postal service, but also modern technologies usually are more efficient, and it will help to avoid situations as the one that was solved in the judgment of the Supreme Court of Spain delivered in October year 2015.
Well, the case, it was crazy, kind of crazy, but I cannot just read it, the whole case because we are running out of time. We have spent more than an hour, and I'm going to summarize the idea. This couple have a domicile in London and separate domiciles in different villages in the province of Madrid, in Spain. So in this case, the absurd situation arose when in a small claims procedure held in Madrid against them, the Madrid court tried to summon the spouses at their London domicile, when in fact they were living only a few kilometers away from the court at that time. The thing is that there was not a case of, it was not a fraud and it was not bad faith. The thing is that they were just spending time in their domicile in Madrid, but the court decided to summon them in London, and it was, of course, unsuccessful. And so as a result, the whole process took place without the attendance of the defendants, and they requested the rescission of the judgment, proving that the service was never delivered, that it was a kind of like stupid thing, because they were just close to the court and the judge continued to serve them in their London domicile.
Well, another area that will benefit from the use of modern technologies is that about the possibility of holding a oral hearing. As you all know, the proceeding is governed by the rules of the procedure of each member state. But in any case, the provisions of Regulation 861/2008 shall be applied. Well, Article 8 of the regulation already provided the possibility of using modern technologies in the oral hearing. And, but the possibility, but despite this possibility, the celebration of a oral hearing, the holding of a hearing, was really reduced. And this restriction about the possibilities of holding the hearing was really striking if we take into account that the possibility of the use of modern technologies should make easier for the court to admit the oral hearing. The party has to request the holding of the hearing, but the judge may grant or may not grant it. So it is not enough to request it. In addition, the party has to argue the need for the hearing in order to have it taken place. This is what happened in the case solved by the Appeal Court of Barcelona in September year 2012.
Well, in this case, the plaintiff alleges that oral hearing had been denied. He requested it, that the right to hold this oral hearing, and the courts denied it. He said then that when he filled the objection form, he requested the oral hearing from the court in order to gather the necessary evidence. And therefore, on the basis of Article 5 of the regulation of the small case procedure, the refusal can only be made if it was clearly unnecessary, which is ultimately consistent with paragraph 9 of its preamble that establishes the right of a fair trial and the adversarial principle, especially when it's ruling on the need of the oral hearing. Well, there's no doubt that the rationale behind this regulation, as we have seen throughout the whole presentation, was to establish a speedy, eminently written procedure, and therefore the judge can refuse to hold a hearing, oral hearing, when he considers that it is clearly unnecessary. And this is what happened, as the appellant cannot argue its necessity to gather evidence when the judge himself, and in order to the provisions of the preceding articles, the fact that is not mentioned in the appeal, require the appellant to state the means of evidence it considers of interest, precisely to determine the need or not to hold the hearing. It also stated, of course, that it was only documentary evidence. If it was only documentary evidence what the party wanted to bring, the hearing would be unnecessary, and the period giving elapsed without the appellant making any statement of the evidence he intended to use. So if he let this opportunity pass, he cannot claim that it should be granted again in a hypothetical hearing. The court says that if the defendant is defenseless, as he said, it is only due to his own behavior, and given that he does not indicate, even now, what his evidence would be, nor does he give any argument against the grounds of the judgment, referring to the merits of the disputed issue, the judgment must be confirmed with rejection of the appeal. Nothing really important apparently could be raised in an oral hearing.
Well, let's move to the last of the problems we would like to underline about the regulation of a small claims procedure that refers to the right to appeal. As you may remember, Article 25 of the regulation of year 2008 established that in the information that every member state should provide to the Commission must be included the availability of the appeal in the domestic law. At that moment, Spain announced the availability of the appeal held in the Spanish domain for the small claims procedure. But in domestic law, the availability of appeal was suppressed in year 2011 for civil claims under 3,000 euros. At that moment, many people wonder if that could apply also to the European process. But Spanish legislator established later an exception for small claims procedure whose judgments were considered to be appealable in any case. Some years later, the possibility of this issue seemed to be solved in our domestic law. But in year 2016, Spain informed the Commission that the judgments delivered in decisions in a small claims procedure could not be challenged by means of an appeal. This has been highly contested by the academics and the practitioners. First, because it means an unequal treatment compared to national proceedings. Let me remind you that in Spain, from 3,000 euros to 5,000 euros, that it's now the limit of the small claims procedure, in that range of amount, 3,000 to 5,000 euros, there is the possibility to appeal. But at the same time, it does not allow the creation of case law. So if we could offer to you some examples of judgments delivered on appeal in the different courts of appeal of Spain, it won't happen anymore, because there is not the possibility of appeal, not to mention, of course, the Supreme Court of Spain. So this is really an issue that it's not very, it has not a well reception from the academics and practitioners. And we would like to offer you some conclusions of our presentation. First of all, in our opinion, a small claims procedure is not very effective for very low debts. I mean, that is a fact, but being honest, neither is the internal process, the domestic process. In these cases, litigation is simply not very effective. I mean, in these very low debts, ADR, or I mean, conciliation or mediation could be an effective means. Second conclusion, it seems to us that the amendments of the year 2015 are going in the good direction. I mean, they try to booster the application of this proceeding, and we will probably see in the years to come how it is implemented, I mean, widely. And finally, small claims procedure has very clear objectives, but we think it is necessary still some amendments for the recovery of debt. So we are on the good way, but we are still on the way. And finally, we would like to say that we regret deeply not to have the possibility to meet all the attendants in person. But anyway, we would like to thank you for your attention, and we hope to have the opportunity at a better moment to meet you in person. Thank you.